Beautiful people, it's me, Pamela, on my YouTube. Cho, no, what's the T? Siyahlazia.
This witness is going to testify about the computer-generated extracts from the NATIS system. And my lord, the sole purpose of presenting this evidence is to refute the version of accused number one. This witness is going to testify that and show those extracts of the application that was made by accused number one for a learner license, and this information was then captured on the NATIS system. And as I've intimated, my lord, this is to refute the version of the following version of accused number one. During the evidence of Mr. Zungu, S.S. Zungu, on the 8th of September 2023, page 27 to 28, the following was put by Mr. Ramusepeli, and I'm going to refer to line 18. Mr. Ramusepeli, accused one will state that in 2013 until March 2013, he was staying in Foslores Hostel at Basituni section, but when he lost employment in March 2013, he returned home and stayed home until he returned again to stay with his uncle in Tembisa in 2015. Then proceeding to page 28. Mr. Ramusepeli then asked Mr. Zungu to comment. Then Mr. Zungu says the following: I would not know where he was working when he lost his employment. We have never discussed that. Now, my lord, the following is very important. Mr. Ramusepeli says the following: the basis of that proposition to you is essentially this, that since March 2013, he has never returned to Johannesburg or Gauteng until 2015. That is the nub of the matter, my lord, and the state will then present evidence via this witness that shows that accused number one did apply for a learner license in person at Brakpan Driver's License Testing Center. The acronym DLTC is often used, on the 17th of July 2014, that he then undertook the learner's test on the 22nd of July 2014, but unfortunately he did not make it. That he then, on the same day, the 17th of July 2014, on the 22nd of July 2014, made another appointment at the Boksburg License Testing Center, Boksburg DLTC. As I indicated, this is now on the 22nd of July 2014. And he then secured an appointment for the 15th of September 2014 to sit for the learner license. And that on the 15th of September 2014, he then passed his learner's.
I'm not sure if the state is leading evidence.
Yeah, he says he's telling the court and even you just cancels what he intends leading this witness upon.
Yes.
So the evidence will be led, according to him, by Mr. The surname, by the way, is Mr.
Matlou.
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 Matlou. Matlou.
Yeah, Matlou. Matlou, ne? You know the Matlou who was a member of the Gang of 8? Oh, you don't know him? Okay,
No,
fine.
no.
Yes, sir. There's an objection there.
Yes, my lord. As I said, I'm just with a broad brush, just outlining the relevance of this witness evidence, and I've covered that aspect. I'm not going to go into that.
Okay.
And we'll then refer to Section 17 of the National Road Traffic Act 93 of 96 that says a person must apply for a learner license in person. As there's a certain questionnaire that the applicant must complete regarding the health status. Now, during his evidence, my lord, will also traverse the certain infringement notices that were issued to some of the accused, and the sole purpose thereof, my lord, is simply to show that the accused were stopped whilst driving the particular motor vehicles by a traffic officer.
Sorry, my lord, I'm going to do the same objection that my learned colleague.
Yeah, maybe just lead the witness.
Yes. As I say, I foresee that there'll be an objection, and I'm just trying to explain the reason why, and just so that everybody can follow the evidence, my lord. This is not giving evidence. I'm just outlining the evidence so that everybody can follow it.
What's your objection, Mr. Ramosepedi?
My lord, the summation that my learned colleague is giving comes from the affidavit of the witness. The witness will testify about that.
Is that so?
I've read the affidavits, man.
So what's the problem? I thought you didn't know what this witness was going to say.
But
So you know what this witness is going to say?
Shouldn't the evidence come from the witness?
No, I'm saying...
I do know.
You know?
Yes.
Okay, they say they know.
I'm almost done, my lord. And the state is then, as far as these computer-generated printouts are concerned, the state will be relying on the act that governs the printouts, and it's the Electronic Communications and Transactions Act 25 of 2002. There's also a decided case, my lord, of Ndlovu versus Minister of Correctional Services. It's a decision of the then Witwatersrand Local Division given by Judge Gauchi.
This procedure is totally wrong. Mr. Baloyi, my colleague, Advocate Baloyi, just needs to lead this witness. In an event that there's an objection, then he can respond. It is unnecessary for him now to, even before this witness begin to proffer testimony, to refer this court to a particular authority.
Okay.
That will only come if and when there's an objection with regard to the testimony of this witness.
Okay.
Otherwise, the presence of this witness here will be rendered very nugatory if Mr. Baloyi persists.
Yeah, but that's not evidence. Anyway, just lead the witness. Swear the witness in.
As a court, please, my lord, can I just make this point? In terms of Section 150 at the beginning of the
You relay the text.
can lay out
I know
the
that.
basis of the case, and during the presentation of the evidence of any witness, there's nothing that stops.
Maybe let's
the
read
state
Section 150. Let's read it.
Yes, but
Because maybe some of us don't know it.
That relates mainly to the opening statement.
Yes, I know.
Reads as follows. Prosecutor may address court and adduce evidence. There's a heading. The prosecutor may, at any trial, before any evidence is adduced, address the court for the purpose of explaining the charge and indicating without comment to the court what evidence he intends adducing in support of the charge. Then subsection 2, The prosecutor may then examine the witness for the prosecution and adduce evidence as may be admissible to prove that the accused committed the offense referred to in the charge, or that he committed an offense of which he may be
That's
convicted
enough.
of the
That's
charge.
enough.
Yes.
The first portion covers what you're saying.
Yes. Okay.
Is that not so, Mr. Ramusipiti? Section 150 covers what this gentleman has been saying here. Try and lead the following evidence.
My understanding of the section, unfortunately, this is written in a very small font. It says, without comment to the court, what evidence...
No, start the section from where it starts.
Okay. The prosecutor may at any trial, before any evidence is adduced, address the court for the purposes of explaining the charge and indicating without comment to the court what evidence he intends adducing in support of the charge. Without commenting. That's what I'm underlining, my lord. And also, this process is done at the commencement of the trial, not when a witness is seated before court.
Okay.
Yes, I'm done, my lord. Just explaining. I was just showing the relevance of this.
Okay, quite. Thank you.
Your full name and surname? I'm Chupe Christopher Batlou. Do you have any objection in taking the prescribed oath? I have no objection. If you do not have, do you swear that the evidence you shall give shall be the truth, the whole truth, nothing else but the truth? If you do swear, please raise your right hand and say, so help me God. So help me God. Witness sworn in, my lord. Please come to the front.
My lord, this witness is going to make use of his affidavits. He has made 2 affidavits, and he's going to refer to his affidavits, my lord. This will be in terms of section 212, subsection 3 of the Criminal Procedure Act, and section, if my learned friend can just give me time to finish, as well as section 15 of the Electronic Communication and Transaction Act 25 of 2002.
25 of 2002.
Yes, section 15.
Yes, Mr. Ngomalo.
My lord, I have a problem because when my colleague addressed the court, he referred to accused number 1. Hence, this evidence, the evidence of this witness also relates to my client, of which, my lord, I object on the basis that the evidence that is going to be tendered by this witness in respect of my client is irrelevant. It does not address the core issues in this case. Hence, we are dealing with the matter in relation to the 5 counts as per the indictment. Thank you.
You say the evidence you want to adduce from this?
Maybe, my lord, I do not intend to hijack the stage. Mr. Baloyi, in his address, informed the court that the testimony of this witness will only have an effect on accused number 1.
Yeah, he said so.
Thank you, my lord.
Yeah.
Yes.
Are you going to also lead evidence against accused number 4?
No, I'm actually taken aback at these objections.
Yeah.
I was interrupted, my lord, when I was still trying to
apply number 4.
the relevance of the evidence.
Okay.
Now, they are saying the relevance hasn't been shown when they stopped me from showing the relevance.
Just listen to me. But you intend leading evidence against number 4?
All the accused, my lord.
Okay, all the accused. Fine. Let's start, please.
Regarding the cell phone numbers,
yeah, fine.
That links up with the evidence of Colonel Stein, as well as the addresses that they gave.
Okay. Because if the evidence is irrelevant, you counsel, through cross-examination, you will demonstrate that. If he says the rain falls mainly on the plains of Ikopo, and for the past 100 years there was no rain there, that's it.
Yes.
Yes, let's continue.
As you please, my lord. As I've indicated, the witness has made 2 statements which are covered in terms of section 212,
Yeah.
subsection 3 of the Criminal Procedure Act,
Right.
as well as section 15 of the Electronic Communications Act
Okay.
that I've referred to, my lord.
Okay.
Thank you. The witness is also going to make use of the screen to do his presentations. If the system allows it, he will drill into the NATIS system and just to demonstrate his evidence.
Okay, fine.
And perhaps for the convenience of the court, we've also begged leave to hand the two affidavits that he's going to use, just to make it easier for the court to follow the evidence as well.
Thanks.
ngamafuphi umnumzana Baloyi ulibele uyachaza ukuthi ufakazi lona ubufakazi bakhe buzobonisa ukuthi nina nonke nanikade nisebenzisa mhlawumbe ama-license noma ama-learners noma imoto laniye namiswa khona ngamaphoyisa kulesikhathi lesi eyikuthi umnumzana uRamsile kathe umsola wokuqala ngo-2013 ukuyofika 2015 wayekade engekho eGoli, wayekade esekhaya. Ufakazi uzobonisa ukuthi umsola wokuqala wayekade ekhona nabanye kukhona okunye okusazoboniswa.
There's also, my lord, the Volkswagen Polo that featured in the confessions. The evidence of this witness will traverse a vehicle of that make, my lord.
Okay.
Nale moto iVW ekukhulunywe ngayo ngalesikhathi kugonyuluka kuthiwa nayo ubufakazi bayo buzobonakaliswa ukuthi leyo moto ekabani eyanini kanjalo. Bonke ubufakazi bakhe buchaza imininingwane yonke yomuntu oke wasebenzisa i-license noma umuntu oshayelayo. He has been sworn in, yes.
Mr. Matlo, is that correct?
Yes, my lord.
That you have prepared two affidavits that I want to show you. The first one consists of 22 pages. And this.
I've got an objection, my lord. I think I can't allow this to continue unabated.
Yeah, what's the objection?
Mr. Baloyi, even before this witness starts to testify, he hands in an affidavit that is purported to have been written by this witness. Now, a section 212 affidavit simply replaces the oral testimony of this witness. But if the witness is there, then there's no need for that 212 affidavit, unless Mr. Baloyi intends to introduce to the court, even before the testimony of this witness, the documents as annexures that are attached to the affidavit. But the affidavit itself should not be handed over to the court when the witness is here.
Yes, Mr. Baloyi, what do you say?
Well, my lord.
212, what does 212 say?
I should maybe read section 212, subsection 3. And it reads as follows. Whenever in criminal proceedings, the question arises whether any matter has been registered under any law or whether any fact or transaction has been recorded thereunder or whether anything connected therewith has been done thereunder, a document purporting to be an affidavit made by the person who in that affidavit alleges that he is the person upon whom the law in question confers the powers or imposes the duty to register such matter or to record such fact or transaction or to do anything connected therewith, and that he has registered the matter in question or that he has recorded the facts or transaction in question, or that he has done the thing connected therewith, or that he has satisfied himself that the matter in question, or that he has done the thing connected therewith, or that he has satisfied himself that the matter in question was registered, or that the fact or transaction in question was recorded, or that the thing connected therewith was done, shall, upon its mere production at such proceedings, be prima facie proof that such matter was registered, or, as the case may be, that such fact or transaction was recorded, or that the thing connected therewith was done. But there's nothing, my lord, that stops the affidavit is by mere production admissible, but there's nothing that stops the state to lead viva voce evidence. This happened with the pathologist. There was no objection when the pathologist, my lord, read his affidavit in the record. And just
there's a difference, my lord. This witness is not an expert.
Well,
he's just a mere witness that comes from natives. He's not an expert. So that's the difference.
Are you agreeing that this witness is not an expert?
Well, the state is going to contend that he's an expert on the in-artist system.
They contend he's an expert.
Yeah, he's an investigator attached to the RTMC, and that he's an expert on the Nazi system. But
yeah, you can bring evidence to dispute that.
Yes.
No problem.
Can I also, perhaps just for clarity, also put section 15 of the Electronic Communication Act on record, so that we are all on the same page. And it reads as follows: admissibility and evidential weight of data messages. And data messages, my lord, is defined in section 1 as data generated, sent, received, or stored by electronic means, and includes A, voice, where the voice is used in an automated transaction, and B, this is the one that we are relying on, a stored record. Now, the section itself reads as follows: section 15, the heading is admissibility and evidential weight of data messages. Subsection 15.1, in any legal proceedings, the rules of evidence must not be applied so as to deny the admissibility of a data message in evidence, A, on the mere ground that it is constituted by a data message, or B, if it is in the best evidence, if it is the best evidence that the person adducing it could reasonably be expected to obtain on the grounds that it is not in its original form. Subsection 2, information in the form of data message must be given due evidential weight. Subsection 3, in assessing the evidential weight of a data message, regard must be had to A, the reliability of the manner in which the data message was generated, stored, or communicated. B, the reliability of the manner in which the integrity of the data message was maintained. C, the manner in which its originator was identified. And D, any other relevant factor. Then lastly, subsection 4, a data message made by a person in the ordinary course of business, or a copy or printout of or an extract from such data message certified to be correct by an officer in the service of such person, is on its mere production in any civil criminal, administrative, or disciplinary proceedings under any law, the rules of self-regulatory organization, or any other law or the common law admissible in evidence against any person, and rebuttable proof of the facts contained in such record, copy, printout, or extract. That is section 15.
Okay.
If we can then maybe proceed with the evidence of the witness.
Yes, let's hear you.
Mr. Matlo, you've indicated that you've deposed to 2 affidavits regarding the matter. Is that correct?
That is correct, my lord.
Iqiniso ukuthi wena ubhale ama-affidavit amabini ngaleli cala uthi yebo iqiniso.
I just want to show you your first affidavit consisting of 22 pages.
Ngifisa ukubonisa i-affidavit yakho yokuqala enama-page awu-22.
And if I can draw your attention to the last page, page 22 of that affidavit.
Asiyeke ku-page 22 yaleyo affidavit.
Or maybe if we can start at page 21.
Aqale ku-page 21.
There's a signature there. Whose signature is that?
It's my signature, my lord.
Kunala kusayinwe khona ubani osayine lapho uthi yimina osayinile.
And the next page, page 22, the affidavit was commissioned. Is that correct?
That is correct, my lord.
What is the date thereof?
The 9th of October 2023.
Ku-page 22 kunala i-affidavit eyachifizwa istamp khona uthi iqiniso idate yayithini uthi kwakuyi-9 zika-October 2023.
Are you the one who prepared this affidavit?
Yes, my lord.
Will you confirm that?
Wena umuntu oyenzele after lama affidavit uthi yebo.
Do you confirm its correctness?
Yes, my lord.
Uvumelana nayo ukuthi yonke into ebhale lapha iqiniso uthi yebo.
If I can draw your attention to the next affidavit that consists of 27 pages.
Asiye kwenye i-affidavit enama-page awu-27.
If I can ask you to refer to page 25 of 27.
Ngicela uye ku-page 25.
There appears a signature there. Whose signature is that?
It's my signature, my lord.
Kune-signature lapho ekabani uthe yami.
And the following page 26 and 27, the affidavit was commissioned. Is that correct?
Yes, my lord.
And what is the date on which it was commissioned?
23rd of September.
Which year?
2023, my lord.
Le affidavit kunalapho uthi yaqhishizwa istembe ya commissioniwa uthi yebo nini uthi nge-23 sika September nyakeni.
But we will return to these 2 affidavits just in a while. If you can just put...
It is the court, my lord. Before this witness starts to proffer his testimony, I would like to place this on record that these affidavits were already commissioned on the 9th of September 2023. The other one was commissioned on 22 September 2023, last year. We only received this information on Thursday, on Wednesday. I would also love the state to put it on record why from 23 September 2023 and 9 October 2023 this information was not made available to us. And therefore on those bases I would object that this information, that this witness should be proceeded with unless the state brings out reasons why this information was not disclosed then. Otherwise, this will constitute a trial by ambush. It constitutes a trial that is not fair to this accused persons. The state has been in possession of this document for almost 6 months, if my calculations are are correct. You only gave them to us on Wednesday. Thank you.
Yes, Mr. Matron.
My Lord, I really do not wish to cast aspersions on my colleagues, but this thing of, I've given you documents and they say they haven't received it. My Lord, last year, before we started with the evidence of the tracker expert, I personally came to this court, found my colleagues sitting here in court consulting, and I gave them this affidavit.
There's 2 affidavits.
I remember in particular the one affidavit, my Lord. I'm not too sure about
last year too.
Yes, last year.
They say they got them Thursday.
And out of courtesy, my Lord, just out of sheer courtesy, because we know that these things are misplaced, we then gave them again the same affidavit that I personally gave to them here in court last year. I think Mr. Dupree's evidence was around October, thereabouts. I personally gave them this affidavit. And as I say, my Lord, I really don't want to enter into a debate where we, we cast aspersions at each other, but I give my word
so
to the
to
court.
The state,
I did personally.
Personally,
Yes.
last year?
Yes.
Not Thursday, not Thursday.
None. Well, Thursday, as I say, just out of courtesy, we know that
other copies.
It's a long time ago, and I again gave them this affidavit. And Mr. Mnisi said on Wednesday he's ready.
He's ready to proceed.
He said we must postpone the case to today and not to Monday because he's ready. Now he's ready. He's saying, but he didn't have enough time to go through the affidavit.
As it is the court, it's not a matter of trying to cast some aspersions. It's a matter of procedure. It is true that on Wednesday I indicated that we'll be ready to proceed today, but I was not aware that we'll be confronted with information that we should have received already last year.
Okay, fine. So,
and I can tell the court, my Lord, that if my memory is not bad, I never received this report, and I cannot stand up here and mislead the court and say I did not have this information when I actually received them. Maybe my colleagues received them. I'm speaking on behalf of myself, who's representing accused number 3. I never received this information.
Sorry, Mr. Did you give it to each and every of the representatives? Each and every one?
Yes.
From the representative?
In fact, on that day, the investigating officer personally brought it in the morning. We made copies, and we then brought the copies along. And she sits here and she can vouch to that, my Lord.
Is that the Sergeant
Mohola?
Mohola.
Yeah, she was in Kota. It looks like she's
not here.
out. And
she's not here?
Yeah.
Oh, okay. You say she
brought it
documents
to me, yes.
But did she see you when you gave them to each and every one of them?
I cannot remember if she was present, but...
You know what my problem is? I've got 2 officers of the court, or 5, 6, 7, 20. They're giving this court 2 different versions. And we want to dignify by saying, we never got this. It means Baloyi is lying. If Baloyi tells this court that he gave you all this affidavit, and you say he never did, it means he is lying. It must be so. What's your problem, sir?
My Lord, if I might clarify, without throwing Mr. Baloyi and Advocate Baloyi under the bus, I personally, my Lord, received the one affidavit, not the second affidavit, as Mr. Baloyi says, last year.
Last year?
Yes.
So he favors you, he just gives you alone.
That's why I say I'm not sure about
and then
other
I see you're standing up to you.
Yes, I did receive the
last year.
Yes, I did.
Please, let's continue with this trial. Mr. Nis, if you want time to read these 2 affidavits, tell this court how many months or years you need, so that we postpone, especially for you, because you say you never received them until Thursday. So, Mr. Ramusipi, you said you received them last year.
Only one, my Lord.
Fine. Mr. Numalo, now you received it last year.
I did receive it last year.
You wouldn't know, Mr. Mnyeke. Is that so?
I don't know.
So you want us to postpone for you, sir?
I'm not suggesting any postponement.
No, you say you haven't had time, in other words, to prepare.
No, those are not my words, my Lord. I am saying that on account of the fact that these documents were already deposed to last year in
But he has
October.
explained, Mr.
Yes.
Misi. Uti, he gave them to you last year. He has explained. What more must he say?
But I am telling the court as well, Malot, in
Yeah.
as much as Mr. Baloyi
So you
is
never
saying-
received them last year?
No, I never received
Fine.
the document. Because if I received them, I would have consulted with
how
Mr.
much time
Miniwe
do
on
you
them,
need?
Malot.
How much time do you need to read them and prepare? How much time?
My Lord, I'm going to come up with a panacea, which is a universal solution. I don't want to waste this court's time. This witness may proceed to testify, and if there are issues that I think I need to take up with them as they would be affecting Mr. Miniwe, then I will approach the court with the amount of time that I may need to go and consult.
Didn't you guys have a pre-trial conference?
No.
Mr.
Well, there was a pre-trial conference in Palm Ridge, Manot, where the matter initially appeared, but none of these defense counsel were present then. Yeah, there was a different set of legal representatives at the time. The court would recall that they only came into the picture after the matter started,
Okay, fine. All right, so Mr. Mnisi, you say this witness can proceed. If there's any issue you want to canvass, you do so.
Most definitely.
Okay, fine. Okay, let's go on. And even you, Mr. Ramsepi and Mr. Mgomezo, should this witness continue giving evidence?
That's correct.
Nyeke?
That is correct, my lord. Thank you.
Hey, my lord. Yes, sir.
Mr. Matlow, where do you work?